jury must not disparage the witnesses, court personnel, or the jurors. I think if he goes after the jurors, there'll be another citation for contempt in addition to the 20 or so citations that he now has. The judge seemed to be lenient with regard to disparagement of Michael Cohen, where Cohen had attacked him. He had some sort of right of retort. So although he didn't identify Cohen by name, it was obvious he was talking about Cohen, called him a sleazebag, and he undoubtedly was advised or felt that he had a certain latitude in attacking Cohen, who's been on television attacking him.
Jim, we heard a lot about the trial itself from Donald Trump earlier, said it was very unfair. When the government wanted something, they got everything they wanted. We wanted a venue change. We didn't get it. I paid a lawyer, totally legal. He says it's a legal expense, not sheetrock. It's not construction. It's a legal expense. What would you say back to Donald Trump after what just transpired in court the last 7 weeks?
Well, tell me what legal services Cohen rendered. The jury believed Cohen. We have to accept that. And the expense was incurred to cloak in secrecy the payment to the porn star, Stormy Daniels, to cover up the tryst. No legal services were involved. This was arranged by Michael Cohen, and he was the fixer, the arranger, the enforcer for Donald Trump. And in fact, he went to jail over this very transaction because he was indicted for it in the federal court.
Yeah, indeed. And of course, the fact that he was indicted and many other things came to light over the course of the trial, or certainly were made note of repeatedly. To go back to something else Joe was just talking about, though, in terms of what Donald Trump said this morning about what he perceived to be unfairness with the way all of this played out, he had a few specific assertions about what wasn't allowed to happen in the courtroom, what testimony could not be heard from certain witnesses that he wanted. Is any of that going to have merit in the appeal process?
I don't think so, and whatever he asserts in the appeal process, he'll have to back up with facts, which he hasn't done in this 33-minute rant you just heard at Trump Tower. It is not true that his witnesses were not permitted to testify. He wanted to call a campaign finance expert, and the judge allowed it, but narrowed the scope of what he was going to be allowed to testify about. And that's standard practice. The law had to come from the judge. It doesn't come from an expert. Otherwise, you'd have a battle of experts, and that would preempt what the jury is supposed to do.
Donald Trump also talked, Jim, about his decision, or at least what we thought was his decision to not testify. He said, "I would have testified." This is a quote. "I wanted to testify. The theory is, though, you never testify, but I would have loved to." What would have happened if he chose to testify in his own defense?
I think if he had taken the stand, number one, he would have been cross-examined on the substance of the transaction and his role in the transaction. And there, he would have had to admit his role, which was a contested issue in the case, or he would have been faced with further charges of perjury. Secondly, the judge did allow limited cross-examination. He made that in response to a motion that is always made at the beginning of the trial. And he said there were certain areas that the prosecutor could go into if Trump took the stand, and certain which had bearing on credibility. And there were other areas he was not going to allow the prosecutor to go into. So there's the so-called biased judge making rulings in favor of Trump.
Well, and certainly the biased judge or the corrupt judge, to use whatever language that Donald Trump has been using to describe Juan Merchan, as well as the idea that this was, as he repeatedly has said, a Soros-funded district attorney in Alvin Bragg, the idea that all of this was brought upon him for political reasons. I feel like it's worth just making it clear, though, Jim, even if that were true, if these charges should never have been brought, as Trump and many other Republicans have said, the fact that a jury found enough merit in the evidence to convict him in all 34 counts, should that then therefore essentially make moot that entire point? Because even if you question the motive of these charges being brought, ultimately 12 everyday Americans that the defense agreed could serve as adequate jurors decided Trump was guilty of these crimes.
Well, in the first place, the charges were brought by a grand jury in New York County. We don't know how many of those grand jurors, I suppose there were 23 of them, were Republicans. We don't know how many of them liked Trump. We just don't know what their biases and prejudices were. They have said again and again and perpetuated the lie that Bragg ran for office on a platform of getting Donald Trump. That's not true. In fact, he avoided discussing the Trump case when he was running in the primaries, and he got the Democratic nomination, which is tantamount to election. So you cannot say that Bragg brought these charges because he was a biased prosecutor determined to get Trump, or he was fulfilling a campaign promise. Letitia James, the Attorney General, did run for office on a promise she was going to get Trump, but that's a different question. Bragg, I think, showed tremendous courage here. He's been a great district attorney. Crime is down, contrary to what Trump says. And Bragg was very reluctant to bring these charges until they were totally vetted and investigated. In fact, the fraud charges, which were the subject of a civil case that Letitia James brought against Trump, were not brought by Alvin Bragg. He declined on those charges. He went with these charges because he believed that this would lead to a successful prosecution. He was vilified, he was called a racist, he was attacked, and he went ahead. He's really a profile in courage. And the case went to before a judge in a court of law, and it was presented to a jury, and the jury unanimously convicted. And Bragg is completely vindicated.
Well, lastly, Jim, you know it's our job to ask you what you think is going to happen at sentencing. Is Donald Trump, are we to believe, going to be slicing garlic at Rikers Island?
I think it's entirely possible because in sentencing, the judge takes into account a number of factors. There is the factor of Trump's age. He's 77 years old. That's in his favor, unlikely to sentence a 77-year-old man to jail. Trump, even in his press conference, spoke about his age, and then really realizing that he used that weapon against Joe Biden, he sort of pulled away from it. There's the point that Trump has never been convicted of anything. Well, he's never been convicted of anything because he's managed to delay the 3 other trials that would be had against him in the federal, 2 in the federal court and 1 in Illinois. What would be against him is the panoply of civil cases where he's been found liable, including the E. Jean Carroll case, where he was adjudicated a sexual abuser, where he defamed a woman without any basis whatsoever, and the civil fraud case, where a judgment was entered against him for $500 million. So those are factors which would militate in favor of a jail sentence, plus the fact that Trump is a public figure, and he's a public figure who engaged in a corrupt and illegal act in order to win the 2016 election. And when a public figure engages in conduct like that, judges like to make an example of them, because it will deter such conduct in the future, either on his part or the part of other people who are seeking public office.